All right, hello to all our listeners out there, especially to those prepping for the UPSC exam, those intense international relations sections.
Yes, hello everyone.
International law is kind of a big deal, but like, where does it all come from? What are the roots of these global rules? That's what we're diving into today.
That's right. And unlike, your everyday laws within a country, it's not so simple as just one government deciding everything for everyone. The global stage. It's a whole different ballgame.
So no global Congress calling the shots. Okay, so how do we untangle this web of international law? Where's the starting point?
Well, our source text takes us straight to a pretty crucial document, the Statute of the International Court of Justice, the ICJ. It's kind of the Supreme Court for countries settling disputes and all that.
The ICJ, got it.
Mhm.
So what does this statute say about the sources of international law? Like, where do these rules actually spring from?
Right, right. It outlines four main sources. Think of them as the four pillars of international law. It all starts with international conventions, but most people just call them treaties.
Okay, treaties. Formal agreements between countries. Sounds pretty straightforward. But I bet there's more to it than meets the eye, right?
Oh, absolutely. You've got your bilateral treaties. Those are between two countries. Think of those START treaties between the U.S. and Russia trying to keep those nuclear weapons in check.
Right, two countries, one agreement. Simple enough. What about when you need to get, like, a whole bunch of countries on board?
That's where multilateral treaties come in, agreements between three or more countries. You're talking about major international collaborations here. Think about the UN Charter. That's a prime example. It basically created an entire international organization.
Bilateral, multilateral, got it. But you said earlier that treaties are different from, like, the laws we have within our own countries. How so?
Yes. Here's the key difference. With domestic laws, they generally apply to everyone within that country, right? But treaties, they only apply to the countries that have specifically agreed to be bound by them. It's all about consent.
So countries have to opt in, like, yes, we want to be part of this agreement. No one's forced into it.
Exactly. Consent is the cornerstone of international law, especially when it comes to treaties. Now, of course, once a country signs and ratifies a treaty, they're expected to keep their promises. It's about upholding international obligations. There's actually a fancy Latin term for that, pacta sunt servanda.
Pacta sunt servanda. Okay, I'm going to need a translation on that one. What does that mean?
It basically means agreements must be kept. It's a fundamental principle, the bedrock of the entire treaty system.
Sounds pretty serious. So no wiggle room. Once you sign, you're stuck.
Well, there is a counterpoint, a recognition that things can change drastically in the world. It's called rebus sic stantibus.
Rebus sic stantibus. Another Latin phrase. Okay, break that one down for me. What's the loophole here?
Not exactly a loophole, but it acknowledges that circumstances can change dramatically, right? So rebus sic stantibus, it means things thus standing. And it suggests that if the basic conditions under which a treaty was signed change significantly, a country might argue they're no longer bound by it.
I see. So, like, if there's a major war or a regime change, something that shakes things up.
Exactly. We're talking massive shifts that alter the very foundation of the agreement. And this idea of agreements, of states choosing to participate, it all goes back to this concept of positive law.
Positive law. That's a new one. What exactly do we mean by that?
Positive law in this context refers to international law that comes directly from those concrete agreements between countries. It's not based on some vague moral code or natural law. It stems from the choices and actions of states themselves.
So it's grounded in the real world, what states actually do, not just some theoretical ideal.
Right. Countries coming together, hammering out those agreements, setting the rules. It's a very practical approach.
Treaties, consent, positive law. Okay, I think we've got a handle on that first source. What's next on the ICJ statutes list?
Next up, we're diving into international custom. It's also known as customary international law. It's a bit more subtle, this one. It's about how states actually behave, not just what they formally agree to.
So less about those signed treaties and more about established patterns of behavior. Give me an example. Like, how does this customary law thing work in practice?
Sure. A classic example is diplomatic immunity. It's this idea that diplomats working in foreign countries have certain protections and privileges. They can't just be arrested or sued in the host country, and it's not always specifically laid out in treaties.
It's like a tradition, an unwritten rule that everyone kind of understands.
Yeah, exactly. It's evolved over time through consistent state practice. It's become an accepted norm. And that's how customary law often works. It's not written down in a fancy treaty, but it's binding because countries have consistently behaved in a certain way.
Interesting. So how is it different from treaties? With treaties, it's all there in black and white.
Right. With customary law, consent isn't explicitly given. It's more like it's implied from actions. So consistent state practice, if it's accepted as legally binding, well, it becomes the rule. And unlike treaties, which often have specific countries involved, customary international law can actually have universal jurisdiction.
Universal jurisdiction.
Yeah.
Does that mean it applies to everyone, even those who haven't officially signed on to anything?
Potentially, yes. Especially when it's rooted in really deeply held norms and moral principles. It's like a global code of conduct going beyond borders and specific agreements.
Sounds pretty powerful, but also kind of tricky. If it's not written down, how do we even know what counts as customary international law?
That's the challenge. Defining it can be messy. It's about interpreting things, figuring out how consistent and how long a practice has been going on and whether it's truly accepted as law. There's a lot of room for debate and disagreement.
I can imagine. So how do we bring some clarity to this? I mean, it sounds pretty vague.
Well, that's where the push to codify customs into treaties comes in. It's about formalizing those unwritten rules, making them official, bringing more structure and certainty to things.
Okay, taking those old practices and giving them a proper legal framework makes sense. You mentioned earlier that customary law can be super powerful, especially when it's tied to, like, strong moral principles. Can you elaborate on that?
Absolutely. The prohibition against genocide is a great example. Even if a country hasn't signed the Genocide Convention, the customary prohibition against genocide, well, that's widely considered binding. It's seen as this fundamental principle of humanity. It goes beyond any formal agreement.
A powerful example of how tradition and morality can shape international law. Okay, we've tackled custom. What's the third source of international law, according to our trusty ICJ statute?
All right, the third one's a bit more abstract. It talks about general principles of law recognized by civilized nations. This one comes into play when treaties and customs don't give us a clear answer.
So, like a safety net. When the other sources don't have the answers, we turn to this.
Exactly. It's about taking those basic legal principles that are widely accepted in domestic law, within countries, and extending them to the international level.
Like if something is considered a crime in most countries, it should probably be seen as a crime internationally, even if there's no specific treaty about it.
Yeah, you're getting the idea. Let's say one country invades and takes over territory from another country. Even if there's no specific treaty that's been violated, that action can be condemned under international law because it goes against those general principles of how civilized nations are supposed to behave.
So upholding those core principles of conduct, even when there's no explicit rulebook to consult. Interesting.
Now we've got one last source of international law to cover.
All right, hit me with it. What's the final piece of the puzzle?
The ICJ statute mentions judicial decisions and the teachings of the most highly qualified publicists of the various nations. Basically, it's looking at court rulings and legal scholarship.
So it's about turning to experts, to court decisions, to legal opinions for guidance.
Exactly. Even the ICJ itself recognizes how valuable legal scholarship can be when it comes to settling disputes in international law. It's like seeking wisdom from those top legal minds to help clarify things.
Treaties, custom, general principles, and expert opinions. Wow, that's quite a system, especially considering there's no, global lawmaking body.
It is, isn't it? It shows how creative and frankly how necessary it is to find ways to regulate how countries interact with each other in such a complex world. And for those UPSC aspirants out there understanding all these nuances, it's crucial for really grasping international relations.
It's not just about passing an exam, right? It's about understanding how the world actually works.
Absolutely. This is just the beginning. There's a ton more to explore when it comes to international law.
So much to learn. But before we dive even deeper, we've got to talk about a case that really brings all these sources to life. The Nuremberg Trials.
Ah, yes.
Yeah.
Nuremberg Trials. Such a turning point in history, and a story that still raises big questions about justice and accountability and what it means to have a global legal order.
We'll dive into that after a quick break. Stick around as we explore how the Nuremberg Trials shaped the evolution of international law. And hey, if you're enjoying this deep dive so far, don't forget to hit that like button and subscribe to stay tuned for more.
The Nuremberg Trials. Yeah, even all these years later, just saying the name, it brings up those images of, well, a world trying to deal with the aftermath of just horrific atrocities, really a turning point in the story of international law.
It's definitely a heavy topic. And for those who might not have all the details, like those who are just starting to learn about international relations, can you kind of give us a quick rundown of what the Nuremberg trials were all about?
Sure, sure. So picture this. It's 1945. World War II has just ended. You've got devastation everywhere, and the awful legacy of the Nazis, right? The Allied powers, the U.S., U.K., France, and the Soviet Union. They decided to hold these military tribunals in Nuremberg, Germany.
Nuremberg.
Yeah, and the goal was to put the top Nazi leaders on trial. These trials, they went on from 1945 to 1949, and it was all about holding those responsible for the Holocaust and all the other terrible things that happened during the war, holding them accountable.
Bringing those who were behind such horrors to justice. It must have been, incredibly complex and emotionally draining.
Absolutely. The sheer scale of it all, the systematic nature of the Nazi regime's crimes. I mean, we're talking about the Holocaust, the systematic killing of millions of Jews and others, and countless other war crimes and crimes against humanity.
It's almost too much to comprehend.
Yeah.
And you mentioned some key figures like Hermann Goering, right?
Yeah, Goering was one of the top Nazi officials. He was among the defendants. So you had the world trying to pick up the pieces after this horrific war, and they're trying to hold those responsible accountable.
But how do the Nuremberg trials tie into our discussion about the sources of international law? What makes them so important for understanding where these global rules come from? Good question. I mean, it's about punishment, right? Making sure those who commit terrible acts face consequences.
That's part of it, for sure. But what's really fascinating about the Nuremberg trials is that they went beyond just punishing individuals. They actually reshaped the whole landscape of international law.
So they weren't just about retribution. They were actually a catalyst for changing the international legal system itself.
Exactly. The trials, they brought the atrocities committed by the Nazis into the global spotlight, forcing the world to confront the darkest parts of human nature. It sparked a movement to strengthen international laws that protect human rights, to ensure that there are humanitarian standards during conflicts. You could say that, in many ways, the Nuremberg trials laid the groundwork for what we now call international human rights law.
So it's a shift from just focusing on how countries interact with each other to actually recognizing the rights and protections of individuals. A big change for sure.
A huge change. And the trials introduced a concept that's now central to international law: crimes against humanity. This was a major moment. It was acknowledging that some acts are so horrific, so fundamentally wrong, that they go beyond national borders. They require a global response.
Crimes against humanity. It's such a powerful term that really captures the gravity of those acts. So how did this concept, which emerged from the horrors of World War II, actually shape the future of international law?
Well, the Nuremberg trials set a really important precedent. They established that individuals could be held accountable for these atrocities, even if they were acting on behalf of a state or following orders from their government.
So it's like saying that even if your government tells you to do something terrible, you're still personally responsible.
Right. It challenged this traditional idea that state sovereignty could protect you from being prosecuted internationally for such crimes.
So breaking through that barrier of state sovereignty and saying that individuals are responsible for their actions no matter what their rank or authority might be, that's a huge principle with far-reaching consequences.
Exactly. And it's had a lasting impact on the international legal system. These Nuremberg principles, as they became known, they influenced the drafting of the Genocide Convention in 1948. That's a landmark treaty that's all about preventing and punishing genocide.
So there's a direct link between the trials and the creation of this major international treaty. Are there other ways the Nuremberg trials affected how international law developed?
Oh yeah, the impact went even further. Those Nuremberg principles, they also helped shape the Universal Declaration of Human Rights, that was adopted by the UN in 1948. This declaration basically sets out the fundamental human rights that are considered universal, rights that everyone has no matter what. And it set a new standard for how states are supposed to treat their own citizens and anyone within their borders.
Wow, so the legacy of Nuremberg reaches right into the core of international human rights law. Pretty amazing.
And the impact didn't stop there. The trials also paved the way for those international criminal tribunals we saw for Rwanda and the former Yugoslavia, those were responses to genocide and other crimes against humanity that happened later on. And ultimately, you could say that the Nuremberg trials set the stage for the creation of the International Criminal Court, the ICC.
IACT.
Right. It started operating in 2002, and it's a permanent court whose whole job is to prosecute individuals for those most serious international crimes.
So the Nuremberg trials, they weren't just a moment of reckoning for the world. They were actually a catalyst for lasting change in how we address those international crimes and make sure that those who commit them are held accountable. But you mentioned earlier that the trials weren't without their critics. There were controversies.
Oh, definitely. I mean, when you have an event like this, something that really shakes up the existing legal norms, it's bound to generate debate. And the Nuremberg trials were no exception.
So what were some of the main criticisms? What concerns do people have?
Well, one of the biggest criticisms had to do with the very definitions of these new crimes. Critics argued that terms like crimes against peace and crimes against humanity, they were just too vague, They didn't have clear legal boundaries. And this raised concerns that they could be applied arbitrarily or interpreted differently by different people.
So there were worries about whether these new legal principles were clear and consistent, and whether they could be misused or applied unevenly.
Exactly. And this concern was made even worse by accusations that the trials were basically victor's justice. The winners of the war imposing their own legal standards on the losers.
That age-old problem of history is written by the victors. It's a criticism that often comes up when you have tribunals set up after conflicts.
For sure. And this also ties into another controversial aspect of the Nuremberg trials, the use of what's called ex post facto law.
Ex post facto. I remember that from our discussion of the sources of international law, but can you remind us what that means in this context?
Sure. It basically means that they were prosecuting these defendants for things that weren't technically considered crimes under international law at the time they did them. So the laws were being applied retroactively.
So it's like changing the rules of the game after the game has already been played.
Yeah, and that raises serious questions about fairness and due process.
It's definitely a thorny legal and ethical issue.
Right. And beyond those specific criticisms, there was a broader concern that the Nuremberg trials were pushing international law into uncharted territory, like they were blurring the lines between international law and what should be handled by individual countries.
So some people felt like international law was overstepping its boundaries.
Exactly. Some argued that this focus on human rights and humanitarian intervention could actually weaken state sovereignty, which is, the whole foundation of the international system.
A concern that international law was encroaching on the autonomy of states.
Yeah. The Nuremberg trials sparked a debate about the role of international law and its limits in a world of sovereign states, a debate that is still going on today, really.
So it seems like the Nuremberg trials really did kind of force the world to confront some of those fundamental questions about international law, justice, and how we balance those universal principles with the idea of countries being sovereign.
Yeah, definitely. They brought to light how complex it is to hold individuals accountable for those really terrible crimes, especially while trying to navigate the delicate nature of international relations in a world where you have all these sovereign states.
It's this tension that we still see playing out on the global stage today, right? So where do we go from here? How can we, build on what Nuremberg established while also dealing with these really complicated issues?
That's the big question. The Nuremberg trials, they gave us a framework, some key principles to guide us, but figuring out how to apply them in a world that's constantly changing, well, that's the challenge.
It seems like international law is always evolving. It's a process that never really ends.
Exactly. It's about adapting and refining those rules. And that's what makes it so fascinating for anyone who's into international relations, especially those UPSC aspirants who are really diving deep. Understanding all those little nuances of these sources, how they work together, where they fit, and where they might clash, that's the key to understanding how the world really operates.
It's like you can't just memorize definitions from a textbook, right?
Yeah.
You have to really engage with these ideas, think about where they came from, and see how they apply to the challenges we're facing today.
I totally agree. Take, for example, that concept of rebus sextantibus we talked about earlier. It might sound kind of dry and technical, but when you look at how it's been used in real-world situations, it gets much more interesting.
Can you give us an example of how that principle of rebus sextantibus has played out in international relations?
Sure. Think about when the U.S. pulled out of the Anti-Ballistic Missile Treaty back in 2002.
Okay, the ABM treaty.
Yeah. That treaty was signed way back in 1972 during the Cold War, and the U.S. argued that it just wasn't relevant anymore, given the whole new security environment after 9/11. They actually used Rebus Six Stantibus as a justification for withdrawing.
So a case where circumstances changed so much that they felt like they couldn't be bound by that treaty anymore? I'm guessing that didn't go over well with everyone.
You guessed it, Russia, who was the other party to that treaty, they weren't happy. They argued that the U.S. withdrawal undermined the whole agreement and made the world less stable. It really highlights that tension in international law. Like, how do you balance needing some predictability and stability in those treaty agreements with the fact that the world is always changing?
It's a tough question, one that policymakers and legal experts are still wrestling with today. And it just shows you how understanding these concepts, even the ones that seem really theoretical, can help you analyze real-world events.
Absolutely. And it's not just about looking back. It's about applying those principles to what's happening right now.
Yeah.
Think about, the rise of cyber warfare. How does traditional international law even apply to that?
Yeah, that's a whole new frontier. Do those existing treaties about armed conflict cover things like cyber attacks? Does customary law offer any guidance? How do you even define aggression in cyberspace?
Those are exactly the kinds of questions that legal experts are trying to figure out right now. And for anyone who wants to, have an impact on international relations, whether that's through diplomacy, policymaking, or research, well, understanding those sources of international law, that's your foundation.
It's about having the tools to analyze those really complex issues, to help shape how international law develops, and ultimately to work towards a more peaceful and just world.
Couldn't said it better myself. And for our listeners out there who are just getting started with this fascinating field, remember that this deep dive, it's really just a starting point. There's so much more out there to explore.
So much to learn. Stay curious, keep asking questions, and keep those brains engaged. And if you've enjoyed our exploration of the sources of international law today, don't forget to like and subscribe to stay tuned for more deep dives on all sorts of fascinating topics. We'll see you next time.